Hi, I'm Dr. Rellis, and I want to answer for you here some frequently asked questions on how you can get rid of a past court removal order when you marry a U.S. citizen or legal permanent resident. Can marrying a U.S. citizen or permanent resident help terminate a past removal order? Marrying a U.S. citizen or permanent resident does not automatically terminate your past removal or deportation order. However, it can be a significant factor in seeking relief from that order. How can I terminate a past court removal order through marriage? To terminate a past removal order through marriage, you typically need to file a motion to reopen or reconsider with the immigration court. That motion should present the marriage as a change in circumstances that warrants a reevaluation of your case. Can I file a motion to reopen based solely on marriage? Yes, you can file a motion to reopen based solely on marriage, but it's crucial to present a compelling case demonstrating that the marriage is bona fide, in good faith and genuine, and that it constitutes a significant change in your circumstances. What if I married a U.S. citizen after getting the removal order? If you marry a U.S. citizen after your removal order, you may be eligible to file Form I-130, Petition for Alien Relative, to establish the qualifying family relationship with your spouse. This can be part of your strategy to terminate your removal order. How long after marriage can I file a motion to reopen? There's no specific waiting period after marriage to file a motion to reopen. However, it's advisable for you to initiate the process promptly, especially if there are compelling reasons tied to the marriage that could impact the case positively. Can my spouse sponsor me for a green card despite the removal order? Yes, your spouse can sponsor you for a green card despite the removal order. However, the removal order may need to be addressed through the appropriate legal channels, being the court, such as a motion to reopen or other relief mechanisms. What if my spouse is a permanent resident and not a U.S. citizen? If your spouse is a permanent resident, the process may be more complex and relief options may be limited. You need to consult with an immigration attorney to explore available strategies based on your specific circumstances. Is it possible to terminate a removal order without leaving the U.S.? In some cases, it may be possible to terminate a removal order without having to leave the U.S. This typically involves filing a motion to reopen and presenting a strong case for relief to the immigration court. Can I apply for a waiver of inadmissibility based on marriage? Depending on the circumstances, you may be eligible to apply for a waiver of inadmissibility based on the qualifying family relationship. This can be part of the overall strategy to address your removal order. What happens if the motion to reopen is denied? If the motion to reopen is denied, you may have the option to appeal that decision or to explore other forms of relief. It's imperative to consult with an immigration attorney to assess the best course of action for you. Seeking legal representation is highly advisable when dealing with a past removal order. An experienced immigration attorney can assess your case, guide you through the process, and increase by far the chances of a successful outcome for you. Navigating the process of terminating a past immigration court removal order when marrying a U.S. citizen or legal permanent resident requires a thorough understanding of immigration laws and every update to that law, case-specific considerations, and very careful legal strategy. Individuals facing such situations are strongly advised to consult with experienced immigration attorneys to assess your eligibility, to explore potential relief options, and to pursue the most appropriate course of action for you to fix this problem.